Good evening, everybody. My name's Karen Reay. I'm the Regional Secretary of Unite the Union for the North East Yorkshire and Humberside. This is, we've had a number of panel meetings and discussions with our members and people watching. However, today we're concentrating on legal issues. The questions we've got come from our members have been a bit wider this time. We've covered quite a few on COVID, but obviously we've got to recognise that there is standard employment issues out there as well. So there's a mixture today. So first of all, I'll introduce our BSL interpreters, Lynne and Eze, and then I will go around the panel, starting with Martin.
Hi, I'm Martin Wright, Regional Legal Officer, and apologies, I just had a bit of an internet issue there, so I'm back on.
Howard?
Hi, I'm Howard Beckett, Assistant General Secretary for a number of things in Unite, including legal affairs.
Ranjit?
Hi, my name's Ranjit O'Mahony. I'm an employment solicitor here in Newcastle.
And Paul?
Hi, my name's Paul Scholey. I'm a partner at Morrish Solicitors in Leeds.
And thank you all for joining us. So let's go on to our first question. Okay, I have just found out my workplace is closing. What are my rights? Can I come to Paul first on this one?
Certainly, Karen. So let's assume for a moment that the workplace is going to close and there's nothing that can be done about it. Then even if a workplace is closing, an employer's got a duty to go through a fair process legally, which will start with a consultation, both individually with each of the employees affected, but also on a collective level with the union concerned. And if the employer fails in its duty to consult, then individual employees might have rights to claim unfair dismissal. And in addition, there might be a collective right to pursue a claim for what's called a protective award for failure to consult. Individuals who are made redundant will be entitled to redundancy payments calculated based on age and service, and to notice payments as well. So that in a nutshell are the basic rights associated with a redundancy.
Thank you, Paul. Howard, do you want to add to this one? It's quite a big area that we cover as a union.
Well, it is a big area, Karen, and unfortunately at the moment it's with us, it's real. It's very much what our members are facing is mass redundancies across all of our sectors at the moment, obviously particularly in aviation, aerospace and in hospitality. So our starting position, Karen, as a union has to be to fight to protect jobs, obviously not to accept the narrative that we start from a position of redundancies. At the moment, we have the job retention scheme. It's not working for reasons that we could go on all day about. But what it does say to us is that the employer has an alternative to redundancy, and that alternative is to place people on the job retention scheme. And as our members will know, an employer has a duty to look at all possible alternatives to a dismissal when they're considering redundancy. And obviously the most obvious one at the moment is the job retention scheme. So our position as a union, Karen, is to fight redundancies, take advantage of the job retention scheme, and let's see what we can do as a union and with individual sectors to try and prevent redundancies.
Yeah, I think, Howard, that's a really good answer. I think, we forget sometimes that we should be mitigating the circumstances of redundancy, not just accepting them. Ranjit, would you like to add to this one?
Well, I think Howard's made some really good points there, but what happens when things do go wrong, which they invariably do? And unfortunately, when things do go wrong, that's when a referral is made through Unite Legal Services and you end up speaking to either me or one of my colleagues. That's normally where you end up at an employment tribunal, unfortunately, and we're in the litigation process. There are different time limits with these types of claims, depending on the type of claim that you're bringing. As Paul said, unfair dismissal, that's one of the claims that you could bring if you've been unfairly selected for redundancy, and that has a limitation date of 3 months less a day. If you're bringing a claim for a redundancy payment, that has a limitation period of 6 months less a day. And for both of those claims, you need to have 2 years continuous service for you to actually have an entitlement to bring those claims in the first place. One of the claims that Paul spoke about was a protective award claim. Those claims also have a 3 month less a day limitation period. If the union are recognised, that's a claim that would bring in the union's name. If the union aren't recognised, that's a claim that would bring in the individual's name. So it's what we would call a group claim, where there's more than one individual who's affected. So those are the different types of claims that you bring, and they'd all be dealt with at the employment tribunal. Where you have a member who has an entitlement to a contractual redundancy payment, if they would also have a very strict limitation period of 3 months less a day. But you can only pursue those claims in the employment tribunal up to a maximum limit of £25,000. So there's a lot of different claims that you can bring in the employment tribunal depending on the circumstances. And in organisations where Unite are recognised, they'd be able to support their members with that process. Hopefully, we don't end up in an employment tribunal, but if it's necessary, at least the members will have the union support to be able to pursue those claims.
Absolutely. Thank you, Ranjit. Let's move on to our second question. I've been told that I have to sign a settlement agreement. What is that? Quite a simple question. Martin, not so much a simple answer, I don't think.
Yeah, simple question. Absolutely not a simple answer. Look, a settlement agreement, where we tend to see these is where an employer is trying to bring to an end the employment of one or perhaps more of our members. And the purpose of a settlement agreement is really to give the employer some confidence that, having dismissed their employee, the employee is not going to come back and have a go at them. So we would kind of use a settlement agreement whenever we're trying to negotiate an agreed exit for somebody from a workplace. It may be that the relationship is broken down for some reason. Maybe the employer feels somebody's performance is not up to scratch. Sometimes we see these with health-related issues. But at the present time, I think probably where we're going to see them more than anywhere else is where the employer enhances redundancy packages. And this is about giving the employer confidence that they can, sweeten the deal, as it were, for people to leave the workplace. And they can then be confident that the employer is not going to come back, the employee isn't going to come back and have another go. And, if they dismiss them and give them a load of money to just kind of help them out the door, then they're not going to sue them and end up talking to Paul or Ranjit and trying to bring a claim in the employment tribunal. So that's kind of what settlement agreements are all about. But they're, like everything, we deal with them a lot and we kind of get quite used to them. But for members, they can be incredibly challenging. And one of the things that we do is we procure independent legal advice for our members from somebody like Paul or from Ranjit.
Thank you, Martin. And I do think it's absolutely essential that we do get that legal advice, because there is areas of danger around individuals negotiating those. Ranjit, would you want to pick that one up about where we have to protect individuals?
Yeah, certainly, Karen. I mean, you're 100% correct. I mean, the benefit of accessing the legal advice via your trade union is that you're going to get the benefit of speaking to a specialist lawyer who deals with these types of agreements day in, day out. And these types of agreements are incredibly complex. They require detailed scrutiny by a specialist lawyer to make sure that the employee is only agreeing to terms that they absolutely must agree to. And you can only really get that specialist level of advice from a specialist employment solicitor. We need to ensure that the members are receiving the best possible advice, and the cost of obtaining that advice is also covered through the union as well. So the advice itself is independent. The solicitor who's advising the employee on the settlement agreement actually signs the agreement themselves to confirm that the employee has been appropriately advised. So it's a very lengthy and detailed document that we need to ensure that only the member is agreeing to what they need to agree to and nothing further. So hence the reason you need to seek specialist legal advice when you're dealing with settlement agreements.
Martin, did you want to come back on that one?
Yeah, it's just the point Ranjit's making, that the cost of the specialist legal advice is covered by the union. Generally what we do, and because these documents, these agreements are really designed to benefit the employer. I mean, one of the things that members often say to me, this all looks very one-sided, Martin. Is this right? I say, yeah, this is right. It is very one-sided. It is about protecting the employer. But because the employer walks away with all the benefit, we usually insist that the employer makes the contribution towards the cost of that independent legal advice.
Thank you, Martin. It's a really important part. Let's move on now to our next question, our third question. Okay. I'm being made redundant. During my notice period, my employer has said I must use my accrued annual leave. Is this fair? Paul, I'll come to you first on that one.
Right, well, my common sense answer is no, it's not fair. But it's probably legal is the problem. And this is something that seems to have changed recently, and perhaps it relates to the job retention scheme and lockdown and so on. But there was a time, I think, if you were on notice, you could expect that at the end of your notice period, you would receive a nice little lump sum representing the amount of holidays that you'd accrued but not taken. Many employers now, as you say, Karen, are taking a different view, and they're saying, well, if you're on 10 or 12 weeks notice and you've 2 weeks holiday to take, then you must take them during that notice period. So what can you do about it? Well, the first thing is look at your contract of employment, because it might be that there are some restrictions on what the employer can make you do in relation to taking holidays. So start with your contract, and if the contract doesn't help or it's silent about it, then the next thing to think about is the working time regulations, which say that the employer that requires an employee to take holidays has to give twice the notice of the duration of the holiday. So to give an example, if the employer says, I want you to take a week's holiday, then the employer has to give you 2 weeks notice of that requirement. So it might be if the employer leaves it late in the day, that it'll be too late for the employer to force you to take the holidays. A lot will depend, of course, on the value of the deal being offered, and we've touched already earlier about whether the employer might offer an enhanced package, and if the package is enhanced, then of course the holiday pay might be factored into that. You'll need advice about it. The union will support you in negotiating the best deal, and the lawyers can point to what the position is in relation to the regulations or your contract.
Thank you very much, Paul. Howard, can I come to you on this? Because we're definitely seeing this more and more. You know, we're getting cases every day from our members, certainly in this region.
Well, it is completely unfair, as Paul has said. It's unfortunately probably legal. But we as a union, Karen, would fight it. We certainly wouldn't accept it. In an organised workplace, our first response would be to say it's not acceptable. Especially within COVID, there are all sorts of arguments going around at the moment as to whether or not you can force people to take holidays during the COVID period if they're furloughed and at home. Arguments that stem from whether or not it is in fact rest time, because obviously the amount of ability that people have to rest at the moment is very much curtailed, not just physically but also mentally. So from a union position, we would always start by saying, no, it's not acceptable. If it's an organised workplace, we would respond collectively against it. And if you're not in an organised workplace and you're furloughed and at home, object to it on the premise that you cannot enjoy rest time in the current moment.
Thanks very much for that, Howard. So what we're saying is it might be legal, but it's certainly not fair, and we will fight it. So get yourself in a union if you're not already in. Yeah. Okay, let's move on to our next question. I think I caught COVID-19 at work. Can I sue my employer? Oh, Howard, I think I'll come back to you on that one.
Well, listen, there's a range of things to cover with this, Karen. First of all, people should not be taken in by the guidelines that are given out in respect of safe working environments. Everybody in the union, and it's been our starting position, both individually and then collectively, and also with industrial action, and also with people taking action into their own hands by leaving workplaces. Everybody should understand that they should not place their health at risk at the current moment in time. That is in statute, section 44 and section 100 of the relevant employment acts, references the fact that people have a right not to be in an unsafe workplace. And importantly, that's a subjective right. So if you genuinely feel that you're being placed at risk in your workplace, then you have the right to leave that workplace. Don't continue in it. And don't be fooled by an employer's own risk assessments, and don't be fooled by government guidance. If you are at risk from COVID, then don't put yourself at risk. Leave the workplace. And that has happened all over the Union, Karen, particularly in the food sector, where we've had people leave sites because of the failure of social distancing, and rightly so. We've had sites close across the country, the most recent in Anglesey, where there was an outbreak that has affected in the region of 70% of the workforce. Unfortunately, our members took it into their hands and left that workplace because it was unsafe. But if you have contracted COVID and you contracted it because of negligence of your employer, then of course you have a personal injury claim to take. The reality of this is that employers will be placing people at risk. They will be insisting that workers come into work, even though they are non-essential jobs. They will not be enforcing social distancing. And they will want people in work who are exhibiting symptoms of COVID. So if you're unfortunate enough to contract the COVID virus, then you should look at what your employer has done. Have they taken the necessary steps to protect you? Was it foreseeable, if they failed to take those steps, that you were going to be exposed to the virus? And if the answer to that is yes, then you have a claim. We have a COVID personal injury helpline that has been set up specifically for this, Karen, because not only do we obviously want to represent our members who are exposed to COVID and contract it, but we need to know industrially where employers have bad practice, because we need to shut them down where they have bad practice. Because the most important thing in respect to this is, if we have a member who contracts COVID, make sure that no other member contracts COVID. And if that means us taking action against an employer, then we will take the action.
Thank you very much, Howard. I think very comprehensive. Okay, let's move on to the next question. My child's school remains closed whilst my workplace is reopening. I don't have any other childcare. What can I do? And again, I think this is one that we've seen over and over again. The confusion about schools as well has just exacerbated this. So, Ranjit, can I turn to you? Could you pick this one up, please?
Yes, certainly. You're completely right, Karen. This is a really common problem, particularly in the current climate. In today's world, it's still the case that the majority of childcare is provided for by women. It's also a sad fact that the majority of women who remain the main childcare providers also work part-time and are usually also on low incomes as well. The current pandemic is likely to hit this group of workers even more. Anyone who's got childcare responsibilities can make a request for flexible working in accordance with the Employment Rights Act. That allows a procedure for the employee to request flexible working, and it also highlights the employer's obligations when considering such a request. It's a statutory scheme, and it applies to any employee who has at least 26 weeks continuous service, and they can make a request for any reason, and that includes childcare. The procedure is a lot less prescriptive than what it used to be. They need to make a request in writing. That's for the employee to do. And then the employer has a 3-month time limit to make a decision on that request. The employer has to deal with the application in a reasonable manner. And they can only refuse the request for one of 8 reasons that are set out in the legislation. If the employer doesn't deal with that flexible working request appropriately, the employee can complain to an employment tribunal and seek compensation. So that will include where the employer fails to deal with the application in a reasonable manner, where they fail to notify the employee of the decision, where they haven't carried out a fair process, where they've based their decision on incorrect facts, and so on. So it's really important that we look at the reasons why the employer has actually refused the employee's request, if that's what happens. The employee can only make one request in a 12-month period. So we need to be very clear and very careful when the employee is making that request, they haven't already made a request. Another option is that where we're looking at an emergency situation, you're entitled to unpaid time off work to look after a dependent. And again, that's also under the Employment Rights Act, a child would be classed as a dependent. So that's another option in an emergency situation. Obviously, home working would be ideal in this scenario. Sometimes it's not always possible, it's not always practical for an employee to work from home as well as look after a young child. But I would say that if the employer has allowed home working during the lockdown period or has allowed home working in the past, I think they would find it quite difficult to establish that they can't allow home working going forward. So I would say that we need to look at a few different options depending on the circumstances for the employee. Flexible working request, home working. The ACAS Code of Practice provides guidance on flexible working requests. And that's something else that the employee should look at to make sure that the employer is following the correct process. They'd also get advice from their trade union as well, who would make sure that all the boxes are being ticked and that this request is being considered appropriately and reasonably.
Thanks very much, Ranjit. I do think this is a very complicated issue because we've got so many, women, and you're right, it is many women, with the childcare responsibilities, or the majority of the childcare responsibilities, yet they're being persuaded, coerced back to work and feel very, very vulnerable because they have no one else. If they've got elderly parents or parents that are shielding, it does cause a lot of problems. Martin, can I come to you? Because I do know this has been a big, big issue for many of our members.
Yeah, absolutely. And, in the question, it says that the workplace is reopening. So that kind of suggests that maybe the staff have been, perhaps furloughed. And I think one of the key things to emphasize is that the coronavirus job retention scheme is still there as long as people have, the employers have made applications for these people, before now. So the job retention scheme is still there. So, the other thing to add to what Ranjit's saying about flexible working and home working is if the individual's in a post that can't be done from home, then, the furlough scheme is still an option for people who are being try to be dragged back into a workplace that's reopening. But look, I think, the point you're making, Karen, about the disproportionate burden of childcare falling on women is a really important one. And I think employers need to be very careful that they're not indirectly discriminating against women by simply saying to their workforce, look, everybody has to come back to work. It's a must that everybody must come back to work. There's a huge proportion of families that have dependent children are actually headed up. I think it's like 1 in 5 families with dependent children are headed up by single mothers. And if those are families where they're not able to form one of these so-called support bubbles because perhaps they don't have family around, perhaps they don't know their neighbors, nothing like that, then they've no alternative to try and seek, continuing the furlough arrangements or any of the sort of stuff that Ranjit's talking about. So we need to be very careful. Indirect discrimination is a real issue here.
Thanks very much for that, Martin. It's another way to look at it. Howard, did you want to come in on this one?
I did, please, Karen. Yeah, Martin's spot on. These are burdens that fall predominantly on our women members, and all sorts of issues in respect of sex discrimination and gender discrimination. The reality, of course, Karen, is that the government never defined non-essential work through this crisis, and the work that a lot of our members, a lot of our female members do, particularly in the food sector, has continued throughout this crisis, even though it's difficult to imagine how it would be described as essential. And people have been put to great demands in respect of their home life balancing with their working life, and that burden has fallen predominantly upon our female membership, and it's simply wrong. One of our members, Karen, in the East Midlands, said to me, he worked for Sainsbury's, a fantastic activist, and Sainsbury's said to her during this crisis that you're feeding the nation. And she said, well, how about giving me enough money to feed my own family then? And I think this is the point that we have to raise as a collective now, that whenever workers have been described as essential and key during this crisis, that they have to be considered essential and key after this crisis. And if we're dealing with members here who have put themselves in harm's way, now they're troubled with extra burdens in respect of childcare, then as a union, we should take this up. And I'll finish with this, Karen, one overtly political point, that obviously we are not saying that schools should be reopening here. Schools are being proven to be hotspots in respect of the government's rush to reopen society and the danger of putting people's health at risk. And the overtly political point is that Rebecca Long Bailey has been proven correct in respect of expressing her concerns at the speed with which government moved to open the schools.
Thanks very much for that, Howard. Absolutely right. You know, you're talking about key workers. They're going to be key workers. You can't just be key workers in a pandemic. These are people that really need to be respected and have kept our country and our society moving. Definitely. Okay, let's move on to the next question. Bit of a long question, but I think it's very prevalent. I have a health problem as a result of which my employer provides me with specialist equipment when I'm at work. Whilst I have been working from home, my employer said I could not take my equipment home with me. I think my condition has become worse as a result. What can I do about this? Okay, Paul, I think as long as the longer this, people working from home, the more of these cases I think that we're going to see coming forward. So Paul, can I come to you first?
Absolutely, Karen. We're certainly seeing lots of queries from people working at home, and the new ways of working. I think it'll be interesting to see how the whole working from home issue develops in the future, because those employers who've said historically you can't work from home, you need to be in the workplace, people who work at home don't work hard enough or whatever, have found over the last 3 months that in fact lots of people can work effectively from home. So what's the position for people who might have a disability? There's an injury question here that I'll leave for somebody else to answer, but from an employment perspective, the first question is, are you protected under the Equality Act as a person with a disability? So disabilities can be physical or mental, and in the last few years in particular, we've seen a huge upsurge in the number of people looking for disability discrimination protection because of mental health issues. So it's not only what you can see, but sometimes those parts of a disability that you can't see. And if your disability has a substantial effect on your ability to carry out day-to-day activities, so your mobility, your concentration, continence, whatever, lifting and so on, if there's a substantial effect, and if that condition has lasted or is likely to last for a year, then you're probably protected under the Equality Act. And that means that in this context, in relation to working from home, your employer has a duty to make what are called reasonable adjustments to make your life easier. Now at work that can be obvious. It might be installation of wider doors or a more ergonomic desk or working conditions. And some employers seem to think that that ends at the door of the office, and it certainly doesn't. The employer's duty is to continue to make those reasonable adjustments for home workers, and that might mean ensuring that each home worker has a proper risk assessment of their working environment, their workstation, if they're working at a desk, the way that they use telephony, whether they can work just as effectively at home as they can at work. And it seems to me there's no reason now, as we see more and more people working effectively from home, why employers can't bite that bullet and say, we have to be as helpful to our disabled employees when they're working at home as we do when they're in the office.
Thanks very much, Paul. Martin, do you want to pick up on that one?
Yeah, thanks, Karen. I just want to sort of pick up on the point that Paul has beautifully sidestepped, which is the personal injury point.
Thanks, Martin.
Yeah, so, Howard was talking before about negligence in relation to COVID-19 infections and all the rest of it. And this is perhaps a more common type of personal injury type claim that, we would support our members to bring. Look, the establishment of a personal injury claim depends upon a number of things. First of which, you've got to demonstrate that the defendant, the person you're bringing the claim against, has a duty of care towards you. And then you've got to show that they've breached that duty of care. And then you've got to show that that breach caused you an injury. Once you've done that, you've got to show that that injury was reasonably foreseeable. So bringing back all of that to the question being asked here, that we've got a duty of care. We've got an employer who has somebody that they obviously have accepted needs these specialist equipment, and they haven't given that specialist equipment or anything, an alternative. And that is a pretty good establishment of a breach of that duty of care. Now, was it reasonably foreseeable by not giving somebody that specialist equipment that they were going to suffer an injury? Quite probably, because the reason that they've got that specialist equipment is to help them cope with their injury. But look, these cases are, really important, and it's a sort of fundamental part of the way trade union legal services work. Because, most activists, most of our members probably are more likely to see, an employment rights lawyer if they see anybody, or have an employment rights issue, because they might have that conversation with their regional officer or their workplace rep or whatever. But the kind of beating heart of trade union legal services is the personal injury service, because that's what, still sadly people die at work, people suffer life-changing injuries at work. And, safety is a trade union issue, whether it's through, reasonable adjustments for a disabled worker, or, fatal injuries, serious injuries in a workplace. It's really, really crucial.
Oh, did you want to come back on that one?
Yeah, it's just to say, don't forget about your Section 44 and your Section 100 rights. You should not be placed at risk of your health at work. And if your place of work becomes your home and your employer is insisting upon a practice that places you at risk, then you can refuse that practice. And it's all important, because obviously Martin is quite right that there would be an exacerbation personal injury claim if somebody's injuries were exacerbated as a result of what is clearly a foreseeable act by the employer. But we should not permit our members to be placed at such risk. If they feel that their safety is at risk because of the practices of the employer, then they have a right to reject that, and we would take that up for them as a trade union, and they also have that individual right within legislation. I would just make this final point in respect of safety at work, Karen, that it is Mesothelioma Action Day on Friday, and all of us know how important safety at work is, and never has been shown more than people exposed to asbestos.
Thank you. Paul, did you indicate you want to come back on that one?
Yes, Karen, it was simply thinking about what Martin and Howard have both said, how sometimes we see a crossover between employment rights and rights to claim personal injury. And one of the things, I mentioned mental health issues, one of the things that I think we need to think about there is the extent to which people on lockdown have been left to their own devices by an employer to a point where they've suffered mental health issues, either because of a pre-existing condition or because the lockdown itself has created that condition. And it's interesting to me that there are very few employers who can't have seen the guidance that's come out from every quarter now about making sure that employees working at home are supported, are included, are kept informed, that proper communications with home workers are put in place and maintained. And I think we're going to see a fallout here in terms both of employment and personal injury claims for people who have suffered enormously because they've been almost abandoned, to choose a strong word, by employers who said, go work at home and get on with it. So that was the point I wanted to make.
Yeah. Martin, you wanted to, it's obviously a strong issue. This one. Martin, you wanted to come back on this one.
Yes, thanks, Karen. And, whenever we see members coming forward with stress-related personal injury claims or wanting to explore that, they are traditionally very difficult claims to make. And the reason for that is the point that Paul's just made around reasonable foreseeability, that, the employers are pretty much on notice that people are going to suffer psychological, it's reasonable to see that people could well suffer psychological injury as a result of, just as Paul puts it, being abandoned. So, I think it's a really, really interesting point, and sadly, it's one I'm sure we will need to address in the future. The only thing I would add to that is to say to people, I think it's reasonably well known by people that you've got 3 years to bring a personal injury claim, but to everybody listening, just because you've got 3 years, please don't wait 3 years before starting it. There's a lot of preparatory work that needs to be done before ever a claim can be presented in the courts. So yes, you've got 3 years, but that's for a good reason. It's sort of an order of magnitude different from an employment rights claim, but it takes a long time to progress a personal injury claim. So if you think you've suffered an injury, get in touch.
Thank you, Martin. I think listening to the three of you on that subject, what it says to me, and maybe this is something I need to talk to Howard about, is that there's some research and some work on this issue, Howard, that we need to start doing now and not wait, start looking at, what actually is happening out there so that we can try to mitigate it, but also to try and prevent it in the, get into those workplaces and recognise, call out the bad employers, but also look for best practice and try to put that out. I don't know whether you wanted to come in back on that one now.
Karen, you're absolutely spot on, and the advices that have been given are obviously absolutely correct, but our responsibility as a union is to prevent our members being exposed to health risks. And if that health risk presents itself in a workplace, we would step in and we would remove that health risk by threatening industrial action or bringing in outside bodies, because our members should not be placed at risk. And if that risk is at home, then we should similarly step in and prevent that risk. We do not want our members injured, and they have the right not to be exposed to health risks, and we'll take that right up on their behalf. So if a member is out there and feels that an employer's practice is exacerbating a pre-existing condition or placing them at risk of their health for whatever reasons, then contact us and we'll take it up on their behalf, because we don't want their health adversely affected.
Thanks very much for that. Thank you. Now, I know Ryan's been monitoring some of the questions that have been coming through our Facebook comments. So there's one that I've got here. I'll read it out and then I'll decide who to go to first. So it's a shot to you all. What is the panel's view on the success or failure of the government's job retention scheme? Now, I'll leave Howard to last on this one, so because I'm sure he wants to get in on it. So I'll go to Ranjit first, if that's okay. Ranjit, your views on the job retention scheme?
Yep, that's absolutely fine. I mean, let's be honest. It's allowed businesses to stay in business that would have otherwise have closed. You only have to look at the high street and you can see that now things have started to open up, but it's allowed a large number of businesses to remain in business that otherwise would have closed. It's also allowed everyone to be entitled to it, most people. So when I say most people, I mean employees, I mean workers. There's been no requirement for you to have a certain length of service, which you ordinarily would need to have to claim unfair dismissal, i.e. 2 years continuous service, or to be entitled to a statutory redundancy payment, again, 2 years service. There's been no minimum requirement for you to be entitled to payments under the furlough scheme in that way. So it's been helpful because it has avoided, in my view, a large scale redundancies at a very critical time. However, it was a little bit confusing to start with. You know, it wasn't really clear as to the practicalities of it and how it was actually going to play out, to be honest with you. I think now that we're coming towards the end of it, I mean, from the 1st of July, you're allowing employees to come back on a part-time basis. It ends on the 31st of October, but we're not out of the woods yet. What happens on the 31st of October? I think really it needs to be extended until things are back to normal. It needs to provide that further protection for all employees, for all workers, to help to facilitate the economy, to get things back and running. I think the 31st of October is just simply too soon at this stage. It has been beneficial, but I think they can do more. Okay.
Paul, anything, your views on the job retention scheme?
Very much what Ranjit said, Karen. Plainly, it has prevented what would otherwise have been unavoidable enormous numbers of redundancies, and it's sad to see that at the moment that furlough seems to be winding down already. Some of our biggest employers nationally are starting to talk about horrific numbers of redundancies that are going to come rolling in. I agree with Ranjit. I think it's too soon. It's disappointing to me that already, unless you're on furlough, you're not now going to be able to join that. And perhaps it's right now, when we're 3 months into it, when some of the businesses have had to pay their rent for the first time, when they're really feeling the squeeze. Maybe it's now more than ever that we need the furlough scheme rather than limiting it to no new entrants.
Thank you for that. I told you I was going to leave Howard to last. Martin, you next.
Yeah, for me, I think obviously I'd echo what Ranjit and Paul have both said. I think the fact that the job retention scheme has been closed to new entrants, as it were, is really cruel, especially on those workers who have been working hard throughout the early stages of the lockdown and the pandemic and stuff, because these are just early stages to keep businesses running, and they've been working to provide things, and maybe working on the call for PPE and all of that, and perhaps that's now ramping up, and that the need for them to do that work is no longer there, and maybe now those employers would really benefit from having access to the coronavirus job retention scheme. And it's just cruel that it's not there, particularly in recognition of the contribution that those workers have made so far. But I think from my perspective, I'm quite worried about what's coming. Yes, it is the case that the job retention scheme has probably prevented a lot of redundancies. But for me, it's a bit like when you're a kid and you came off your bike and your mum stuck an elastoplast on the skinned knee and you wouldn't let them take it off for weeks, and then you take it off and you've got a pus-filled mess underneath, or maybe that was just me. My worry is when the scheme's gone completely, what kind of a mess are we going to be left with? And as Paul says, I think we're starting to see the pus seeping out the edge of the elastoplast now.
I've just had a visual image. As an ex-nurse, you would never have that in my house. Let me tell you now, you'd never have that. Howard, before I come to you, because there's one thing that really sticks in me, and we've had this discussion with the TUC and others, is the employers that are actually giving notice why they've got people on furlough on the 45 days. That just seems fundamentally wrong to me. So it's open to you. You've heard what everybody else says. You're going to have the last words, I think, tonight.
Yes, well, listen, the reality is the job retention scheme is in danger of being an absolute failure, because the clue is in the title, job retention. Yeah. And if it doesn't succeed in job retention, then it is a failure. For any Labour politician who's watching tonight, I hope some of them may well be, I'm sick to the back teeth of hearing them refer to it as a furlough scheme. The Tories started off talking about it as a job retention scheme. As soon as they realised that it's nothing of the sort, they've started talking about it as a furlough scheme. And we need to get back to talking about it as a job retention scheme. And you're quite right. Employers who have just taken advantage of the scheme are now running down the statutory clock in order to have the scheme pay for their consultation period, pay for the 45 days, making structural changes to their own organisations and not caring a hoot about the fact that workers have contributed to their companies continuing through this crisis and what workers have done for the wider population during this crisis. We talked about workers treating people unfairly while they're at home. You'll know, Karen, we've had members who have committed suicide during this crisis because of the stress that they've been placed under. And we also have employers, and British Airways is the obvious one, who chose to announce 43,000 redundancies, 30,000 re-employed on Workers' Memorial Day. They chose to announce it on the day that British Airways cabin crew were burying one of their own who had contracted COVID from repatriating people from around the world. So the reality is, if this scheme allows that type of behaviour from employers, then it is a failed scheme. It's as simple as that. It has not done what is on the tin, because it was not about the postponement of redundancies. It was about the prevention of redundancies. That was it. And to go through some of the figures today, everybody knows the British Airways figure, but we've got 4,500 in Swissport, 2,000 Royal Mail, 1,700 in Airbus, 270 in De La Rue, 2,000 at Birmingham Airport, 200 Magdalen workers, and so the list goes on. A pandemic of job losses is what's being created by this government's failings, and it should be called out as such, not a success. And listen, Karen, I could talk about this for another 40 minutes, but I won't. But the reality of this is not new thinking, this job retention scheme. It was used by Germany in 2008 after the financial crash, and with a great deal of success. And all countries around Europe had brought it in before this government brought it in. The Labour Party rushed far too quickly to congratulate the government when European countries were tying in the job retention payments to employers having to commit to keep people in employment after the scheme finished. So if you're a cabin crew member of IAG in Spain, you know that because the IAG took the government's money in Spain, your job is protected for 6 months whenever the scheme comes to an end. You've got no such protection in the UK. And that's why it's a failure. And that's why, Karen, we have immediate demands that we are calling on Labour to make of the government. And that is to reverse out the changes for August, September and October. Without reversing those out, we will see mass redundancies because the employers will simply not pay the extra money. Second is that we need to see a sector furlough scheme that is extended into January of next year at the very minimum. Thirdly, we need to see Labour talk about a 4-day working week, which Gordon Brown used in 2008 in the financial crash and was widely said to have protected over 1 million jobs. And Labour need to be saying this with the loudest of voices, that a shorter working week will protect jobs. And then lastly, we need to see job sharing now, Karen. We need to see employers made to share one job between two people. The employer pays 50% of the wage, and a continued scheme pays the other 50% of the wage, because social distancing is not going away. Sectors such as hospitality are years away from recovery. And if we see the exodus of our workers from those sectors, they will never recover. They will leave, they will go back to Europe, and some will go into other sectors where they came from. There will be a skills deficit in those sectors that will simply not recover. But Karen, I'll finish by saying this, because we're all trade unionists here, and we all know that the reality is that this is a negotiation. We're in a negotiation with government, and we do not start a negotiation by saying that we accept redundancies. I don't accept them. People came back from 1945, from the Second World War, and didn't accept that they wouldn't have a society to live in. And debt at that stage was at 3 times the GDP level that it's at now. And what did they do? They built 1 million council houses and they built the social state. So I don't accept any narrative whatsoever that workers should pay for this crisis. There should be wealth taxes, there should be windfall taxes on the likes of Amazon, there should be a proper deal for the rebuilding of our nation's economy. And the scheme that is out there, the job retention scheme, should continue until such time as the economy is back on its feet, because workers didn't create this crisis, they shouldn't pay for this crisis, and they're the only ones that have continued to work through this crisis and put their own health at risk in order for the health of others to be looked after.
Thank you, Howard. I think we all share every point that you made. You know, it is a very difficult situation, but if we're going to move out of this and work our way through this, we have to be brave. And we have to start making very different decisions at a government level to make sure that we have a future. You know, it's not our future, it's the future for the next generations. So on that note, Howard, thank you for that. Ryan, I don't think we've got any other questions. So that just says to me, thank you very much. Thank you to Eze and Lynn as our BSL interpreters. Thank you for our guests. And I'll hand over to Ryan, because I think he's got some update news on another event that we've got.
Thanks, Karen. So thank you everyone for listening, and thank you for the comments. We'll put this video on other channels, so we'll be able to share it on Twitter, so people will be able to share that. Also, you can get some more information regarding Unite Legal Services at unitelegalservices.org. If you want more information about coronavirus and the job retention scheme, then you can go to unitetheunion.org/coronavirus. In terms of future events, on the 29th of July at 5 o'clock, we are hosting a Facebook Live session, and that is going to be women in trade union politics and representation. So take a look at the event on our Facebook page. We're going to be joined by a great panel, so it'd be great to have you along for that session. But once again, thank you for everyone for taking part in today's event and for your comments.
Thank you. Stay safe, everybody.
Thank you.